Coming in the morning. He's ready. If you guys would make sure that all your electronic devices are set to a vibrate or a silent position.
Right, can you have a seat, please? Thank you. Just a second, get this thing set. All right, Today's date is January the 7th, 2016, Seneca Municipal Court here for the purpose of bond hearings. Have Mr. Leroy Morris. Mr. Morris, may you sit up, please? Mr. Morris, do you understand you are charged with unlawful conduct toward a child and infliction or allowing infliction of great bodily injury upon a child? Do you understand that's what you're charged with? Okay. And all right, Mr. Morris, we're here for your bond hearing today. We have the state is represented. Does the state have anything it'd like to offer at this time?
Yes, Your Honor. Lindsay Simmons for the state. Judge, Your Honor, the victim in this case is a female child that was born on November 19th of 2015 named Olivia Barnwell. She has over a dozen fractures, Your Honor, from injuries that occurred various times in the last 2 weeks. Just to outline some of the injuries for you, she has a fracture to each side of her skull, at least 4 rib fractures, a fractured clavicle, at least 4 compression fractures to her spine, a fractured femur, and a tibia that is suspicious for fracture, as well as 2 humerus, Your Honor. There are 2 brain hemorrhages in her frontal lobe of her brain, and she also has brain swelling. Judge, this case was investigated by the Seneca Police Department, and Sergeant Casey Bowling is here, Your Honor, to tell you about their conversations with the defendant. And I would like to be heard as the bond at the appropriate time.
All right, thank you.
Judge, a couple days ago we got notified by the Greenville Hospital System in reference to a child who was airlifted from Oconee Memorial Hospital in reference to skull fractures. Upon our arrival, we witnessed the injuries to the child, and during our investigation it was found that Mr. Morris was the caregiver of the child at the time. He was the live-in boyfriend of the mother. During the interview process, Mr. Morris did state that he did get angry with the child at 2 different events, one event being the 23rd of December and the other event being this past Sunday night. He did state that he got upset with the baby for crying, tried to give it a bottle, dropped the baby on his head, and then stepped back onto the baby as well. The next incident, he got upset with the baby for crying again, decided to shake the baby vigorously, in which after he vigorously shook the baby, he threw the baby on the bed at approximately about 10 feet.
Judge, as you're aware, under South Carolina law, you can deny bond in this case. We are asking you to deny bond at this time. Judge, due to the severity of this child's injury, we would believe that Mr. Morris should be held without bond. Basically, the only part of this child that is not injured is her feet. This is one of the most severe cases of child abuse that I've seen in the last 12 years. And if this man would do this to a child that was barely 40 days old, he is certainly a threat to our community.
All right, Mr. Morris, do you have anything you would like to say prior to receiving your bond?
No such thing as an accident. I didn't do it on purpose.
Okay, all right. Now let me remind you, one, you're in a bond hearing at this time, okay? You're innocent until or if proven guilty. This is just purpose of bond for me to set bond at this time. Do you understand that?
Yes, sir.
Okay. Do you have anything else you'd like to add, sir? Okay. All right. I find that under the facts and circumstances given, it does warrant that the bonds be denied on both charges. Mr. Morris, let me further explain to you, as part of the bail proceedings, that you are required to appear in court. You'll be held in custody at this time. You are also entitled to a preliminary hearing. You are also entitled to an attorney. If you can't afford one may be appointed for you. There are public defender forms at the county detention center. If you'd like to apply for a public defender, they would have that there for you. You are also entitled to a preliminary hearing. A preliminary hearing is not a guilt or innocence phase. It just determines if the state has probable cause for your case to continue to court. You're entitled to this hearing if you request it within 10 days from today's date. In the event you do request a hearing, you'll be notified by the court of date, time, location of the hearing. Mr. Morris, do you understand that, sir?
Yes, sir.
I have a preliminary hearing request form here for you that will be provided to you. And it's kind of self-explanatory. If you wish to request a preliminary hearing, would you please give that to the defendant? All right. Anything else on this matter?
No, Your Honor.
Okay. All right. I want to ask that one of the officers takes this defendant and remove him from the courtroom. That needs to go back with him to detention. Next bond is Whitney, is it Barnwell? Is that correct? Barnwell? Miss Barnwell?
Yes, sir.
Come over, have a seat, please. Miss Barnwell, do you understand that you are charged for 3 counts of unlawful conduct towards a child? You don't have to agree with the charge, but you understand that's what you're charged with?
Yes, sir.
Okay. All right. Does the state have anything you wish to add prior to setting bond?
Yes, Your Honor. Ms. Barnwell has been dating Defendant Morris that you just saw since approximately March of 2015. He is not the father of any of her 3 children. She is charged with 3 counts of unlawful conduct towards a child. Your Honor, all of her children are under the age of 5. The basis of this charge is that Ms. Ballard provided unsafe and inadequate living conditions for the children. DSS is now involved with all 3 of the children. Her infant child is in the neonatal intensive care unit at Greenville Memorial Hospital. Ms. Barnwell also knowingly allowed the defendant to be kept by Defendant Morris, who she knew was abusing alcohol and over-the-counter medications. In fact, shortly before Christmas of last year, Ms. Barnwell came home to find the defendant Morris extremely intoxicated on over-the-counter medications and alcohol. Instead of removing her minor child from that situation, she took the minor child and Defendant Morris to work with her, where they spent several hours in the parking lot while she went back to work, Judge. We understand that bond will be set in this matter, but I would ask that a surety be set regarding this defendant, because she has little to no ties to this community, Your Honor. And, sorry, Bond, you have that?
Judge, to reiterate, we did a search warrant at Ms. Barnwell's residence on the 6th. During the search warrant, it is readily known that the house was not taken care of. It was not clean. It was actually in filth. There was no adequate sleeping arrangements for any of the children. There was one toddler bed that could be used, but it was piled high with stuff to where a child has not slept in that bed in a long time. The baby's crib was not in use. It was more of a storage unit for Ms. Barnwell, and because of those actions at the house, we deemed it necessary to place her under arrest.
All right. Thank you. Ms. Barnwell, do you have anything you would like to say or anything you would like to add prior to bond being set?
Yes, sir.
Okay.
About the alcohol, I didn't know he drunk. I have alcohol in my house, and I had got some Christmas Eve for Christmas. That's the only incident I know of drinking.
All right. Ms. Barnwell, let me. I just want to advise you, make sure you understand this is for a bond hearing, not for any evidentiary value at this time. It's just for the court to consider what type of bond in any conditions that. How long have you lived in Seneca?
2010.
2010. Okay. Do you work?
Yes, sir.
Okay.
And I just want to say I'm I'm sorry, but I need to be with my baby. I love my kids. I need to be with them. I know that I hadn't been cleaning up, and Leroy was supposed to be cleaning up, but I need to be with my baby. That's all I have. That's all I have. I don't have nobody else. Can you please be with my baby?
All right. Anything else?
No.
All right. All right. Again, Ms. Barnwell, this is a bond hearing, bail proceeding. It's not to determine guilt or innocence. This time it's just to set proper bond and certain conditions. I find that a surety bond is warranted in this case. Your bond will be set at $25,000 for each count, totaling $75,000. You would hand that to the defendant, please. And I'll have you stand by her and have to sign required signatures that are needed. Ms. Barnwell, if you look at it, you were charged with 3 counts of unlawful conduct towards a child. Due to the nature, charge, of circumstances, it is a surety bond in the amount of $75,000. They are highlighted in yellow. You will be required to be in the Court of General Sessions on Friday, February the 12th, 2016 at 8:30 a.m. at Oconee County Courthouse, Walhalla for first appearance. You would turn the page, please. On the inside page, the conditions obviously do not leave the state of South Carolina. Other conditions: no contact with the victims in person, by phone, or otherwise without consent of DSS. I understand that these are your children, but you will not be allowed to have any contact with them unless it is approved by the Department of Social Services. Do you understand that? Okay. All right, if you would turn the page, please. Further states that a warrant for your arrest will be issued if you violate any condition of the bail bond order. You have a right and obligation to be present at trial. If you're not there, you'll be tried in your absence. Failure to appear in court could result in a bench warrant being issued and additional charges. You also have a right to a preliminary hearing. You have a right to a trial by jury. The penalty, if convicted on unlawful conduct of a child, carries a sentence up to 10 years for each offense. And you also have a right to an attorney. If you can't afford one may be appointed for you. If you would turn the page, please. This is a specific order for the 10th Circuit. It tells you that all general session defendants shall make an application for a public defender at the clerk of court's office on the first floor of the county courthouse by paying a $40 non-refundable fee within 48 hours you're released from jail. Once you make application for a public defender, you have to wait 24 hours, call the number there, and schedule an appointment for screening. If you are still in custody, the public defender's office should contact you within 3 working days of your arrest, and they would represent you unless until notified in writing that private counsel has been retained. Should you choose to get private counsel, you have to notify the solicitor's office by furnishing a letter of representation from your attorney within 96 hours of your release from jail. You've already been notified of your initial appearance date. You're required to immediately notify the solicitor's office if any change of address, phone numbers, etc., or a warrant could be issued. And if you have failed to apply for a public defender nor retain private counsel as required at your bond hearing, you're subject to bond revocation on your initial appearance date. And you have to comply with all other orders listed. If you would turn the page again, please. The preliminary hearing. This form is a preliminary hearing request form. Again, a preliminary hearing is not a guilt or innocence phase. It just determines if the state has enough probable cause for your case to continue to court. You are entitled to this hearing if you request it within 10 days from today's date. In the event you do request a hearing, you'll be notified by the court as to the date, time, location of the hearing. To request a preliminary hearing, if you'll fill out the lower section of this form and make it return to the Oconee County Magistrate's Court at the office listed there within 10 days from today's date. Officer Sorensen, if you would go back to the inside of the first page and have her sign there on the top. Ma'am, if you would sign there, please. That's not an admission. That's just stating that you have been explained the bond and been given a copy of the bond. If you would, the next page, the special conditions. And that is the special conditions that were explained to you just a moment ago. If you would, please sign that. Again, that's no admission. It's just stating that you have received a copy and have been explained these special conditions. All right. Anything else?
No, Your Honor. Excuse me? No, she's yeah. All right. Ma'am, that's an exact copy of what you just signed for, okay? All right. Defendant can be removed from the courtroom.
Thank you.
Yes, sir. Have a good day. Joe, this actually needs to go with both defendants to the jury.
Yes, sir.
Okay. Thank you.